This hearing starts with what seems like a straightforward plea discussion, but it quickly turns into a tense courtroom exchange. Herbert Kane is facing a second-degree felony charge of assault on a peace officer, and Judge West begins by confirming that he's competent to stand.
And a restitution of $847 to PV, his mother.
Oh, to your mother?
Yes.
To your mother. Okay, all right. I don't know your relationship with your mother, but you should figure out how to get that done. And if you figure out something to pay her back, that's not going to be cash paid through the court system. You need to do that, and she needs to write the DA's office to get it here, because otherwise it will stay with you forever, and I will hound you until the end of your days. And you could go to jail for more and more time. So I'm just letting you know, because again, I don't know your relationship with your mother.
Okay.
So it lasts forever, and you could be on probation with me forever until it gets paid off.
Okay.
Okay.
Right.
That's just a little warning off the record. Are you on probation anywhere else?
Marathon County.
What county?
Marathon.
Marathon. And when does your probation end?
I think it was like 2 years.
In 2 years? So 2027 something?
Yeah.
Like? And that's the only county you're on probation for?
Yes.
What is the count? What is the charge?
I think it was felony bill jumping and possession of methamphetamine, I believe it was.
Okay, thanks. We will go on the record in the matter 25 CF 132, State of Wisconsin versus Angel Moa. The state appears through District Attorney Kevin Schmidt in person. Mr. Moa appears in person with his counsel, Glenn Keene. We're set today for a status, but the parties have reached an agreement. And are we in victims' rights compliance?
Yes, Your Honor.
All right,
Okay.
so we can proceed with the plea and sentencing. The court has an electronic copy of the plea questionnaire waiver of rights form. Mr. Keene, can you please recite the agreement on the record?
Yes, Your Honor. It would call for Mr. Moa to plead guilty to count 1, take and drive a vehicle without consent, with counts 2 through 4 dismissed and read in. It involves a joint recommendation of a withheld sentence for 2 years of probation with conditions of probation, time from arrest to sentencing as conditional jail. That would be 62 days through yesterday. He owes restitution to the owner of the vehicle, PV, that's his mother, of $847. Also calls for an alcohol or drug assessment and follow through.
All right, thank you. Again, I have one more question before we proceed. The co-defendant in this matter, is that a significant other? Do you have a
Small.
co-defendant?
Oh, yeah.
That's your significant other?
That's my girlfriend.
That's what I was wondering.
Oh, okay.
And so you're going to be a father?
Yes.
Do you have any other children?
That's the first one, Your Honor.
Well, that's exciting. So I always like to know as much as I can before sentencing, so that's why I was asking. So,
Oh,
all right. Well, congratulations.
thank you.
All right, Mr. Schmidt, I don't need to go to you right now, but I guess first, this is in the public interest and we are in victims' rights compliance, correct?
Yes, and it is in the public interest. This effectuates getting his mother paid back. I think the probation is appropriate for this offense. Most of his criminal history is status offenses, OWL 2 within 3, misdemeanor bail jumping. All of his history is in Marathon County except one Shawano conviction. So I'm not trying to create like strong ties to here in Burnett County. I think he was mainly just here because his girlfriend is local. Simone is from Sawyer County. The only relevant convictions he has for these offenses would be a fraudulent credit card use in 2009, a forgery in 2015. And
Okay.
that's it.
Thank you. Okay, Mr. Moa, I have in front of me that plea questionnaire waiver of rights form. Did your attorney go over that document with you thoroughly?
Yes.
Did he essentially go over it word for word?
Yes.
And did you understand everything completely?
Yes.
If by chance you didn't understand something, did you have him explain it to you until you did?
Yes.
And I have the unsigned copy right now, but you did review it and sign a copy today, correct?
Correct.
And that has now been filed with the court. You are pleading guilty to one count of felony take and drive a vehicle without consent. You're 35 years old. You have 12 years of schooling. You can read, write, you understand the English language. That's all correct.
Correct.
Your attorney, did he go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did he go over with you the maximum possible penalties you face?
Yes.
No drugs, no alcohol, no mental illnesses or disorders, correct?
Correct.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on that document. Your attorney has that document in front of you right now. Did he thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes.
No longer able to vote in any election until your civil rights are restored.
Yes.
You understand here that the state would have to prove as to count one, felony take and drive, operating a motor vehicle without owner's consent, that on or around September 3rd, 2025, in Burnett County, Wisconsin, you intentionally took and drove a vehicle, a 2009 Nissan Murano, without the consent of the owner, PV. Do you understand what the state would need to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 6 years or both?
Yes.
Do you understand that there is a recommendation here to the court for what's called probation with a withheld sentence? Do you understand what that means?
Yes.
Do you understand what an imposed but stayed sentence is?
Yes.
Do you need me to go over the difference in any detail?
No.
Do you understand that I'm not bound to follow any recommendation by either side?
Yes.
Said differently, I could sentence you up to that maximum penalty, or I can do any array of sentencing decisions if I thought it is warranted. Do you understand that?
I understand.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over that criminal complaint with your attorney?
Yes.
In particular, there's that section called the probable cause section, and it basically says what happened that day and why you were charged with the crimes. Do you remember that?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did take and operate a motor vehicle without that owner's consent?
Yes.
And you knew you did not have that consent?
Yes.
Mr. Keen, may the court use a probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently? Has he done a good job?
Oh, yes.
Has he looked at the matter thoroughly?
Yes.
Has he looked at the discovery, the evidence here and discussed it with you?
Yes.
Has he looked to see if you have any defenses or a lack of defenses in this case?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
Then as to count one, operating a motor vehicle without owner's consent, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept that plea of guilt. Based on that, I will find you guilty of count one. Counts 2, 3, and 4 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. I think we need the probation, one, to ensure the restitution gets paid back. And also, you have to wonder if substance abuse issues are connected to the history, because he does have the prior methamphetamine conviction with the repeater. He's got the 2 prior kind of similar credit card offense and the forgery, which are similar to the taking of the card from his mother in this case. And his girlfriend has a significant history of substance abuse in Sawyer County. So I really think that the probation is going to be necessary, not just to address issues with taking things, but addressing underlying substance abuse issues. So I think that's really why I have it there and why I have it for 2 years. Like I said before, most of his convictions are for OWL 2 within 3 or bail jump, but he has so many convictions for that's why the 2-year probation is asked for it. Like if I had to count this, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, this will be his 25th criminal conviction. Like, I think he's got like 12 convictions, 12 to 15 convictions for OWL and bail jumping. Thank you.
Thank you. Mr. Keen.
Yes, Your Honor. Mr. Moa acknowledges the gravity of the offenses and it's weird because at first it's, a less serious crime because you don't have the force or other things, but as you know, before and on the record, it's a little bit more serious because it has the, harm to the family relationship because it was his mother's vehicle. She, called to try and get back and he, did not return to her. And the joint recommendation does allow for substance abuse needs that Mr. Moa has and have monitoring. In my brief times meeting with Mr. Moa, he's expressed his concern for his significant other, the child he has that's, going to soon be born. And hopefully that spurs him to, do whatever he needs to do to overcome the substance abuse issues that have, derailed his life, derailed a lot of his life so far. He's seemed to be a pleasant man because I've obviously met with him when he's, sober, not under the influence of anything. And he seems like a man who can be a positive member of his community. But if he doesn't take advantage of this opportunity to, deal with his substance abuse issues, the number of prior convictions he has, means that he could end up going away for a longer period of time in the future. And the agreement gives him a chance to, if the court follows it, to demonstrate to the court and, more important, his family, his mother, his significant other, and his soon to be born child, that he can, be the man that they all deserve. And it does have a little bit of, conditional jail to 62 days. It's not a ton, but it's at least a little something just to say that, you have to at least serve some modest amount of jail time just to even get probation for this, because otherwise it, with all the factors in there, wouldn't normally just be a pure probation case without any sort of upfront time. And I think this state, in making the offer and Mr. Moa accepting it, the focus is on showing that hopefully Mr. Moa with his forthcoming child has that extra motivation to, get on the right path and stay on it. And I would urge the court to adopt that agreement so that Mr. Moa can, try and prove to his family and himself that he can be a valuable member of the community and there for his family. Thank you, Your Honor.
Thank you. Before I ask if you want a statement, you wanted to tell me anything, Mr. Moa, you don't have to tell me anything, but if you want to, I want to know, what will it take to get your driver's license? Have you looked into that?
Yeah, I think it was my driving assessment up in it was the healthcare center in Wausau.
What's been stopping you?
I can't tell you the truth. I got no excuse for it, just running around, having fun with friends. So
Can we change that?
yeah, we go, especially with my kid on the way, and I want to change.
Get a dad that can drive.
Oh yeah, definitely. And I've been talking to Pastor Jack, and he said that he's willing to take me under his wing and move me to a different environment where he could help me out a lot. The time that I've been here, I've been going to parenting class. I got at least 6 or 7 hours in Henry, and attending NA, stuff. So
That's good to hear. Anything else you want me to know?
I'm sorry what I did. So
Mr. Moa, I am concerned about the crime that you pled to, the taking and the driving of the vehicle. That's your mother's vehicle. Yep, it's family. Yep, it's your mother. You still have zero right to take her vehicle without her consent or to keep it longer than she agreed to let you keep it. So that is serious, especially it's a felony. You're being responsible and you're taking accountability and you're saying, you know what, I understand I did this. I shouldn't have done this. What is more concerning to the court is that other charge that was dismissed and read in, that possession of methamphetamine, as it weighed with the baggie and whatnot, about 18 grams. That's a lot of methamphetamine. That tells me that there is a substance abuse issue, problem that needs to be addressed. You're admitting that there is one that needs to be addressed. I won't say too much about what your significant other, Ms. Stevens, has said, because her case is not yet resolved. But that's what scares me. That's a lot of methamphetamine. You're going to be a dad.
Yes.
For the first time.
I know.
It's amazing. It's a great experience. You get to raise and to bring up this child who will be and do what you do and will follow in your footsteps and want to be just like dad. Okay. And 25 convictions or so that you have under your belt.
This is the defining moment of the hearing. Judge Melissa R. Mogen explains that the greatest concern is not simply the vehicle offense itself, but the admitted substance abuse problem and the defendant's lengthy criminal history. The court emphasizes that addiction can continue destroying families unless the individual makes the decision to change. From a legal perspective, probation with strict conditions gives the defendant an opportunity to demonstrate rehabilitation while remaining accountable for the felony conviction. The judge also stresses that future violations could result in a stayed jail sentence being imposed. What do you think? When someone accepts responsibility and shows a willingness to change, should courts prioritize rehabilitation, or should repeated criminal convictions lead to harsher punishment? Let's return to the courtroom as Judge Mogen announced.
Life means more to me than the devil drug methamphetamine. So you are the only one who can do that and who can take control of your life. I want to let you know,
Sure.
Miss Stevens is doing well. She looks great. She looks good. Baby looks healthy in her little belly. Got to see her yesterday. All right.
Good.
So you have something to look forward to improving your life and to doing better and being better. Because if you're not, who's going to be there for your baby? Who is?
Nobody.
And you have to be there because you have to be strong to help Miss Stevens be strong. You both have to be there together. Okay?
Okay.
So this is serious because of all of those things. You are accepting that responsibility and being accountable, and you are indicating that you are stipulating to the $847 in restitution, correct?
Correct.
And again, off the record, I told you the only way that you'll stop seeing me is if that's paid off in full, or if you pay off your mother and she writes the DA's office and lets the court know that that's taken care of. But she has to work with the victim witness coordinator and with the district attorney's office with that. So I'm hoping, I don't know your relationship with your mother, I'm hoping that you can mend fences, especially because she's going to be a grandma.
I know.
So you have a lot of inner reflection to do, and you have a lot of apologizing to do.
Okay.
Right? I don't think that the community is at risk or harm for you. This seems like it's a self-use. If there's any hint at dealing or selling, I'm going to tell you, stop right now. You will go to prison, and I want you to be a dad.
Okay.
All right? I
All right.
want you to be a dad. Nothing is worth risking not being with your child. I'm going to follow the recommendation as it relates to probation, 2 years of probation. That'll just go concurrently with the probation you're on right now. I'm not doing a withheld sentence. I'm not seeing this as a prison sentence. I don't know. I'm going to guess you've never been to prison before.
I have.
You have? For what?
For revocation.
What was the charge?
It was for possession of a firearm.
Okay. As a felon?
Yeah.
Okay. But you didn't go to prison for any other felony? Just that one?
That one in bell jumping. That's about it.
Okay. Well, I don't think that this is a prison case. I don't know if your mom wants you to go to prison. I don't have any impact statement to tell me anything of how seriously this impacted her and what she feels. But based upon these facts and what I'm sentencing you for, this isn't a prison case. So I'm going to sentence you to 9 months of jail, imposed but stayed. You're going to be on probation. You're going to be given that chance. I'm going to put certain conditions on you. And if you decide I'm not going to take control of my life and I'm just going to let methamphetamine do that for me, you will be revoked and you will go and sit this 9 months. Okay.
Okay.
And this is going to be 9 months consecutive to any other sentence you sit. So that's the thing, that's that hammer over your head. So if you get sentenced on this Marathon County one, no matter what the sentence is, this is attached. It doesn't run the same concurrently. It's separately.
Yes.
So that's the hammer over your head. I want to give you a hammer because I want you to be the best angel you can be. All right.
I will.
The best dad that you can be. Okay.
Okay.
Conditions are, conditions on probation, absolute sobriety, regular drug testing, no use or possession of illegal drugs, substances, or paraphernalia. I'm ordering that you get your driver's license. Okay.
All right.
Because you need it. And I want you to have that.
Okay.
And I'm going to tell you, that's probably the precursor of what has started sending you and getting other charges, because you get pulled over for not having your driver's license. Get your driver's license.
I will.
Okay.
Okay.
I'm going to do an AODA assessment and treatment evaluation. Okay.
Okay.
I don't know if you've been to treatment, and I don't, if you have and it hasn't worked, sometimes it doesn't work the first time. Sometimes it doesn't work the second time, but you have to want it. You have to really, really want it.
Yes.
And Miss Stevens is in treatment. I want you both to be the best versions of you that you can be, so you can be the best parents that
Okay.
you can be. I'm ordering the $847 in restitution to be paid to PV, 62 days of jail credit. I think that's all. Gainful employment or additional schooling. So I don't know if you're looking at going into a trade or you're looking at doing some type of going additional schooling, secondary schooling, but either gainful employment, treatment, or secondary schooling. Okay. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. $518 in fines and fees for the conviction. I'm going to set up a payment plan, $50 a month until paid off in full. You pay our clerk. Well, I'm going to have you pay our clerk, because that's more of an accountability, because I look at that, and if you miss a payment, I can issue a warrant, and that's separate from your probation warrants. Okay.
Okay.
Because again, that's that other hammer, because I want you to do it this time. Okay.
Okay.
So $50 a month. And the payments will start, I'll start January 2026. So you have some time. So
Okay.
figure out what you're going to do.
Okay.
So you're going to pay our clerk, not probation. Our clerk, not probation.
Okay.
Yes.
Just to clarify on
Oh,
restitution.
we have to do restitution. Never mind. So I can't. It has to go to probation because of the $847. So I have to send it to probation because of the restitution, because that needs to be paid off first. So whatever you're going to do with probation or with restitution, that has to be taken care of first.
Okay.
And then the court costs and fees. So with restitution,
Probation will be collecting
Yes.
restitution.
probation is collecting it. And this is probably one where we're going to have you in restitution court. And that wouldn't be the first time. We have one hearing on our first on January 6th, but we're not going to, I won't need to see you that early. Let me just set right now. And you can appear by video at the next one, because I'm not sure if you're going back to Marathon, or I'm not sure where you're going to be.
Okay.
But I'm not sure where it is. So April 13th at 2:30. April 13th at 2:30, that's restitution court. That's where you're going to update me on the payments you've made, if you've already paid her, and how there's proof, whatever's happening there, because you're gonna have to show that you've made payments. And with that restitution, unfortunately, I have to increase it to $100 a month because that has to be paid off and paid off more quickly. If you're having a significant and substantial financial hardship, you need to write the court and you need to tell me at that hearing. But at that hearing with restitution court, you could have additional days in jail if you're not making your payments. Okay?
Okay.
Very important. You figure that out.
Okay.
All right? April 13th at 2:30.
And the rest of my hand is a little hard to read. but-
Yes, sir.
Court costs and fees come completely after you pay off that restitution. I need your DNA. The jail makes sure that they get that. You can look to see if you can request it be expunged through the system, from the system through a written letter to the Department of Justice. Ask your attorney or Google it. It's pretty easy to do. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Mr. Schmidt, what am I missing?
Nothing for me.
Mr. Keen,
Nothing here, Your Honor.
good luck, Mr. Moa.
Thank you.
This hearing starts with what seems like a straightforward plea discussion, but it quickly turns into a tense courtroom exchange. Herbert Kane is facing a second-degree felony charge of assault on a peace officer, and Judge West begins by confirming that he's competent to stand trial before explaining exactly what's at stake.